Today, our message consists of a series of statements of fact to the top administrator of law in Western Australia, with opportunities for that officer to confirm or deny those statements as facts in law. Dear John Quigley, I write to bring to your attention a matter of serious concern. As a senior officer having responsibility for the administration of law and justice in the state of Western Australia, it is incumbent upon you to ensure that every member of the community has equal access to the due processes of law and that their inalienable constitutional rights are not abridged or infringed by the actions of officers or officials under your overall supervision. Of moment in these matters are the provisions of the 1215 Magna Carta, the primary constitutional document of the British Commonwealth, of which Australia remains a part. Specifically clauses or Articles 39, 40 and 61. As you are aware, the 1215 Magna Carta predates any Parliament by 21 years in the case of the House of Lords and 48 years in the case of the House of Commons. Consequently, the Parliament was formed under the conditions laid down in the constitutional document known as the 1215 Magna Carta, and Parliament has no lawful authority to change or amend any provisions of the Constitution without the consent of the entire community. Do you, John Quigley, deny this as a fact in law? Article 39 of the 1215 Magna Carta states, "No free man shall be taken or imprisoned or dispossessed or exiled or in any way destroyed, nor will we go upon him nor send upon him, except by the lawful judgment of his peers and by the law of the land." Do you, John Quigley, deny this as a fact in law? Article 40 of the 1215 Magna Carta states, "To no one will we sell, to no one will we refuse or delay right or justice." While no one reasonably expects justice to be entirely without cost, for example, via an agreed form of taxation or levy, but not via arbitrarily decided rates of fees paid to those who usurp state administrative power, it is a constitutional right for every person to expect access to due process of law. Do you, John Quigley, deny this as a fact in law? Article 61 is a security clause making it the supreme law of the entire Commonwealth realm that restores freedom from arbitrary or capricious acts of treason by the Crown or its agents. Treason is any act adjudged to undermine or conflict with the people's absolute sovereignty ordained in the Constitution of the people. Do you, John Quigley, deny this as a fact in law? Article 61 is an instruction manual for uniting the people under a solitary process for restoring the rule of law, thus acquiring a redress once treason has been committed. It specifically states more than once that this article shall exist in perpetuity and forever. It also contains a royal command binding not only the barons, the peers of the monarch, but every person in the realm to swear an oath to the Constitution and to distrain and assail the Crown in any way they can to the utmost of their power, saving only the use of violence against the monarch and their family until such redress has been obtained, quote, "as they deem fit," unquote. It finally states that neither the monarch nor anyone else shall ever procure anything which revokes or diminishes the concessions granted by this article, and that if any such thing is ever procured, it shall be null and void, and never used by either the monarch or anyone else. For the sake of brevity, the full text of Article 61 is given in the link provided in the comments. The English Commonwealth Constitution allows Parliament to present statutes, but the monarch must not enact into law any which infringe legem terrae, the law of the land cited in Article 39 of the 1215 Magna Carta. The trial by jury, in which the people are represented as randomly selected jurors, judging the legitimacy of the law, forms an additional, indeed a supreme safeguard of the people's liberties. Do you, John Quigley, deny this as a fact in law? The 1688 Bill of Rights expressly commands the monarch to sign and execute Parliament's laws. The bill states that without the consent of Parliament, it is illegal for the monarch to suspend the execution of Parliament's laws. This means that if Parliament passes a law taking the kingdom into governance by the European Union, then a monarch must sign away sovereignty to that foreign power. Do you, John Quigley, deny this as a fact in law? Yet, to give authority to the bill for that purpose gives authority to all its other clauses, to wit, those which destroy the people's sovereignty secured through trial by jury, the sole and precious source of their liberties emplaced forever by the Constitution. The mass of the population are thus enslaved to the improper whims of Parliament's members through their treasonously acquired parliamentary sovereignty. Do you, John Quigley, deny this as a fact in law? Do you, John Quigley, deny that the 1688 Bill of Rights, passed into legislation in 1689, is in operation here in Western Australia? Do you, John Quigley, deny this as a fact in law? By 1681, there was no one remaining within the establishment and its government-perverted justice system willing to represent the ordinary folk and the constitutional common law code of equal justice, Magna Carta of 1215, by which even the poorest are explicitly empowered both to prosecute cost-free and to protect their rights for themselves through annulment by jury. Do you, John Quigley, deny this as a fact in law? The people realm of the English Commonwealth has perpetual sovereignty over the law through the trial by jury, and any activity which attenuates or attempts to attenuate the sovereignty of the juror. Do you, John Quigley, deny this as a fact in law? Judges themselves comprise a branch of government, and they are in the pay of government. Police, prison services, and above all, prosecutors and judges are employed to enforce government legislation. Such personnel should never be asked nor relied on to decide impartially whether legislative laws are just, for they must fulfil their task or face the fury of the government, their employer. Do you, John Quigley, deny this as a fact in law? For the foregoing reasons, governments and judiciary, justices and judges are incompetent to require the conviction or punishment of any person for any offence whatever. Do you, John Quigley, deny this as a fact in law? As a result of treason committed by Queen Elizabeth II when she broke her coronation oath by granting royal assent to the Treaty of Nice Act, which granted sovereignty over Great Britain to foreign powers, namely the European Union, Article 61 was duly invoked by the Committee of Barons according to correct constitutional protocols on March the 23rd, 2001, and is now in effect. Do you, John Quigley, deny this as a fact in law? The problem which I bring to your attention, John Quigley, is that all three of these articles or clauses are currently being breached by officers under your overall administration. To the best of my knowledge, part of due lawful process is that people accused of crimes or offences are entitled to raise lawful objections to the charges and have those objections dealt with by due lawful protocols. For example, to qualify as a lawful instrument, a notice must emanate from a physical address and bear the full name of the issuer, together with a wet ink signature. Do you, John Quigley, deny this as a fact in law? The recipient must be afforded the right to respond with a lawful instrument under the same requirements. Do you, John Quigley, deny this as a fact in law? If a person makes a statement via a lawful instrument, it must be rebutted or it stands as a fact in law. Do you, John Quigley, deny this as a fact in law? If these requirements are no longer a part of the lawful process, I require you, John Quigley, to quote me the constitutionally valid law which has removed them from that process. You are hereby advised, John Quigley, that the Registrar of the Fines Enforcement Registry, T. Lazara, is in breach of these requirements. Notices are emanating from that department which have no physical address to which lawful notices may be returned. Enquiries have been made to the Sheriff's Office, which gave the assurance that lawful notices sent to Locked Bag 3000 at the Fines Enforcement Registry would be received by T. Lazara. One lady, whose identity is withheld for the purposes of this video, has sent 2 notices to T. Lazara at this address by registered post, but Australia Post has assured her that although they were delivered, T. Lazara has not accessed them, but instead continued to send out notices which contain menacing and unlawful threats. These threats include increasing the amounts of money demanded and cancellation of drivers and vehicle licences and immobilisation and impounding or confiscation of property, to wit 1 motor vehicle. Other people have been threatened with the summary garnishing of their bank accounts, again before the completion of the constitutionally guaranteed lawful processes. These threats and demands breach Articles 39 and 40 of the 1215 Magna Carta, because they threaten summary justice without due process according to the law of the land, which is constitutional law, not legislative acts of Parliament. Do you, John Quigley, deny this as a fact in law? A principle of the secular common law in Magna Carta 1215 is that no judgment, verdict and sentence can be valid against a party's money, goods or person, including a judgment for contempt or costs, unless it be a judgment rendered by a unanimous jury following the common law trial by jury, viz. Article 39. Do you, John Quigley, deny this as a fact in law? More seriously, these actions by your officers breach Article 61 of the 1215 Magna Carta, whereby all people of the British Commonwealth are commanded to distress the Crown in any way they can. Such a condition would clearly include disobeying orders issued by people claiming to be Crown agents who were in fact employees of foreign corporate bodies, evidenced by the existence of ABN numbers and registration on the US Securities Exchange Commission pursuant to the Securities Exchange Act of 1934. Do you, John Quigley, deny this as a fact in law? Articles 39 and 40 emphasise that due process is obligatory, so to proceed to summary punishment while matters were still undergoing legitimate lawful process is clearly unlawful behaviour. Do you, John Quigley, deny this as a fact in law? Under all these circumstances, the cancellation of licences and the interference with or confiscation of property would constitute serious crimes against constitutional law, classifiable as treason, and actionable via torts or commercial liens over the property of any such offending officers and or their overseeing administrators, including such as T. Lazara and yourself, John Quigley. Do you, John Quigley, deny this as a fact in law? An order to someone to cease using their motor vehicle or allow it to be forcibly removed from them would, under the conditions described here, offend all three of the Articles 39, 40 and 61 of the 1215 Magna Carta, would therefore be treasonous and unlawful and would not have to be obeyed, but would in fact be actionable as crimes themselves. Do you, John Quigley, deny this as a fact in law? The people in question have been caused great stress by these unlawful threats, and any damage done to their property, interests, health or reputation is going to be costed and the guilty parties eventually called to account, including in trials by jury for treason in front of people well versed in constitutional law. The number of commercial liens and torts which will accrue to yourself and those officers under your administration, unless you instruct them immediately to start complying with true lawful processes, is going to quickly swell, as many more people are becoming aware of the law as it now stands, particularly Article 61. Each of these claims for damages is going to run into tens of thousands of dollars, to say nothing of eventually having to answer charges of treason, misprision of treason and sedition, if public, i.e. written denials of constitutional law should eventuate. Under your constitutional contracts as guardians of the law, you each become personally liable for acts of treason, whether committed under your own volition or because of obeying unlawful orders. Do you deny, John Quigley, that this is a fact in law? It is an established principle under both constitutional and, since the Nuremberg trials after World War II, international law, that the claim "I was just following orders" is not an admissible defence. Do you deny, John Quigley, that this is a fact in law? The supreme law, as expressed by our common law constitution, provides us with the straightforward mechanisms of trial by jury, judicature by which to accuse, indict, prosecute, measure, judge and punish any person's malicious acts. Do you, John Quigley, deny this as a fact in law? The persistent incitement by attorneys of litigation or lawsuits without legitimate claim, for example where there is no victim of an action or inaction and or no material witness to any criminal act, is defined in law as barratry and constitutes a crime because it creates a victim or victims. Do you, John Quigley, deny this as a fact in law? Any attempt to claim that barratry is no longer a crime because of its removal from statute by legislative act which would therefore permit vexatious or frivolous prosecutions for the purpose of raising revenue by practitioners of law, would constitute an offence against constitutional law as laid down in the 1215 Magna Carta, and such acts would be made null and void by the final sentence in Article 61. Do you, John Quigley, deny this as a fact in law? When Article 61 was invoked on March 23, 2001, the Queen was of course constitutionally deposed until the treason was remedied, and it follows that all other agents of governance or officers or agents of the Crown were also obliged to stand down and consider their oaths. Do you, John Quigley, deny this as a fact in law? We are all subject to the law, John Quigley, and you are commanded to instruct those officers under your administrative oversight to start complying with it without delay. Please find attached my own notice of lawful standing under Article 61 of 1215 Magna Carta, necessitated by the widespread and ongoing breaches of lawful procedure described herein, emanating from alleged officers or agents of the Crown under your general administration. Sincerely and without malice, ill will, vexation or frivolity, and with all rights reserved. Signed. Thank you for watching.